Loud. Welcome everybody to an exciting, I hope, panel discussion with visiting Phi Beta Kappa visiting scholar and law professor at UCLA, Adam Winkler, Rick Rosen of Texas Tech School of Law, Kim Harris of Texas Tech School of Law, sponsored by the Phi Beta Kappa Society. Phi Beta Kappa was founded in 1776. It's the oldest and most prestigious honor society of its sort in America, championing arts and sciences and fostering freedom of thought and recognizing academic excellence. Members include 17 US presidents, 42 Supreme Court justices, and more than 150 Nobel laureates. The Greek letters Phi, Beta, and Kappa stand for the phrase Philosophia biou Kubernetes, or the love of learning is the pilot of life. The Lambda chapter here at Texas Tech has been active since 2011. Since our founding, we've won the national organization's top chapter award twice, recognizing the number of events that we host each year, as well as our history of inducting nearly 100% of the students we invite to join every year. We pay the lifetime dues of each of those inductees, and we buy them an engraved gold key, which is the symbol of the society. We select new members based on their record of academic achievement and their breadth of interests that cover the arts, the sciences, the humanities, law, foreign languages. We were so excited to have Adam Winkler here that we weren't content to wait for his talk tomorrow at 4 p.m. Central Time on the Second Amendment. We asked him and two amazing members of the Texas Tech University School of Law, Professor Rick Rosen, Professor Kim Harris, to discuss the legal implications of the law formerly known as Texas Senate Bill 8 for reproductive healthcare rights in Texas and across the country, really. To give us a bit of background about the law, Professor Rosen will begin. Richard Rosen is the Glenn D. West Endowed Research Professor of Law and the Director of the Center for Law and Military Policy at Texas Tech University School of Law. He joined the law school faculty after retiring as a colonel in the US Army, where he served for 26 years as an officer in the Judge Advocate General's Corps. You may remember him from the hit TV show JAG. In fact, he was commandant of the Judge Advocate General School in Charlottesville, Virginia, lovely town. He's been honored with the Defense Superior Service Medal, the Legion of Merit, the Meritorious Service Medal, the Army Commendation Medal, the Army Achievement Medal, and the National Defense Service Medal. He served as the Dean of the Law School here at Texas Tech in 2017. He has presented extensively on sexual assault and due process in the armed forces, as well as sexual assault on college campuses. He's written and spoken on many aspects of the law and war, and filed an amicus brief to the Supreme Court in the Hamdan versus Rumsfeld case about Guantanamo Bay and the Geneva Conventions. Professor Rosen?
Thank you. Thank you for inviting me. I'm going to go quickly through both SB 8, the Texas Heartbeat Act, as well as quickly summarize the Lubbock Sanctuary City for the Unborn Ordinance, which is similar to the Heartbeat Act. And so I'm going to go through these fairly quickly. It's not going to be fully comprehensive. We'll probably cover other sections during the discussion. Bottom line with the Heartbeat Act, except for medical emergencies, the act prohibits abortions after a physician detects a fetal heartbeat, usually the 5th or 6th week of pregnancy. There is no exception for pregnancy due to rape or incest. The act also prohibits those who knowingly engage in conduct that aids and abets the performance or inducement of an abortion through insurance or otherwise, and subjects them to civil lawsuit along with abortion providers. And that's true even if they don't know that the abortion would violate the act or whether the abortion occurs at all. The act explicitly prohibits public officials from enforcing its provisions. Instead, any person other than a public official may sue any person who performs an abortion in violation of the act or who aids and abets in the violation of the act. And a claimant can bring a lawsuit anytime up to 4 years after the violation occurred. If a claimant prevails in a private lawsuit, the court must award injunctive relief, prohibiting the defendant from either carrying out abortions or aiding and abetting them, statutory damages of not less than $10,000 for each violation, and costs and attorney's fees. Importantly, the Act does not recognize as a defense a defendant's reliance on court decisions that have been overruled. Even if the court decision had not been overruled at the time that the defendant engaged in conduct violating the Act. Simply put, there is a case before the Supreme Court now called Dobbs, which will undoubtedly come up in the conversation, that is an existential threat to Roe versus Wade. And if it overrules Roe versus Wade, defendants can still be sued for abortions carried out or conducted before the Dobbs decision is issued. The consent to an abortion by the mother is no defense to a lawsuit under the Act. And a court may not award attorney's fees or costs to a defendant in a lawsuit. Venue, the court in which the plaintiff can file suit, the county in which the plaintiff can file suit can be in any county in which the plaintiff resides. That means, for example, that a plaintiff who lives in Sierra Blanca, Texas, in Hudspeth County can sue an abortion provider in Houston and force that abortion provider to come to Sierra Blanca more than about 600 miles away. And finally, the Act contains what has been described as a one-way fee shifting penalty, under which civil rights plaintiffs who challenge the Act can be held liable for their opponents' attorney's fees and costs unless they sweep the table on every issue that they raise. So, for example, if someone successfully challenges the Act, say based on due process, but the court doesn't decide or dismisses an equal protection claim, the plaintiff can, or the plaintiff can still get attorney's fees for that particular claim. Now, the Act has had at least two challenges that we'll talk about, I'm sure, in much more detail. One is a case called Whole Women's Health versus Jackson, in which a consortium of abortion providers sued to enjoin the Act and declare it unconstitutional. The U.S. District Court for the Western District of Texas, Judge Robert Pittman, denied the defendant's motion to dismiss. The state defendants appealed under the something called the collateral order doctrine. Fifth Circuit stayed the decision, and the Supreme Court refused to lift the stay. In a second lawsuit, United States versus Texas, the United States sued the state of Texas, seeking to enjoin enforcement of the Act and declare it unconstitutional. Judge Pittman also is hearing this case. He denied the defendant's motion to dismiss and entered an order that, among other things, enjoined all Texas judges and clerks from entertaining lawsuits under the Act. The Fifth Circuit, the Court of Appeals for the Fifth Circuit, the Federal Court of Appeals that under which Texas falls, has stayed that decision as well. Brief word about the Lubbock Sanctuary City Ordinance. It flatly prohibits all abortions except when there's a medical emergency. It asserts that the Texas statutes still consider abortion to be murder, and that while Roe versus Wade and its progeny may prevent enforcement of the Texas statutes, they remain on the books and continue to exist as the law of Texas until repealed by the Texas legislature. Spurred by right to life activists, similar ordinances have passed in about 35 other Texas towns, as well as some towns in Nebraska and Ohio. Lubbock is the only city that I know of that has adopted this ordinance that has a Planned Parenthood clinic. And in fact, the Lubbock City Council, when this came before it back in November of 2020, unanimously rejected the ordinance. Thereafter, enough Lubbock citizens signed for a referendum on the ordinance. And on May 1st, 2021, nearly 2/3 of voters in Lubbock approved the initiative. Lubbock City Council then approved the election results, and the law became effective on the 1st of June, 2021. And like the Texas Heartbeat Act, the Sanctuary City Act forbids enforcement by public officials. It recognizes two types of claims or lawsuits. One is a lawsuit, civil suit for damages against persons who violate the ordinance brought by either the mother of the unborn child or the father, the grandparents, the siblings, and half siblings. That the mother fully consented to the abortion is no defense to liability. And any private citizen of Texas may sue persons who violate the ordinance to obtain injunctive relief and statutory damages of not less than $2,000. Planned Parenthood of Lubbock sued the city in federal court to enjoin enforcement of the ordinance and declare it unconstitutional. The United States District Court in Lubbock, however, dismissed the lawsuit for, among other things, lack of standing.
Excellent. Thank you, Professor Rosen. I just wanted to let everybody, all the attendees know that I'll be taking questions via chat. If something occurs to you and you really want to ask, even while they're talking, I'll take note of that and put together questions for our panelists. Our second panelist, Kim Harris, is a visiting professor at Texas Tech University School of Law. Her research focuses on the intersection of constitutional law and social movements, with an emphasis particularly on reproductive rights, making her our big expert today. We are looking forward to her article, Ultra Compelled Abortion Providers' Free Speech Rights After NIFLA, forthcoming in the next issue of the Albany Law Review. And she's also currently working on a paper analyzing SB 8. So take it away, Kim. Thanks.
Hi. Well, I think it's fairly uncontroversial that SB 8, or the Texas Heartbeat Act, is unconstitutional under current court precedent. I know the court is going to be hearing a case on whether all pre-viability abortions can be prohibited or not this term. But the current law is that the law of Planned Parenthood versus Casey, which says that a state can't pose an undue burden on a woman seeking a pre-viability abortion. And this law clearly does that. It bans all abortions after a fetal heartbeat is detected. And I say that in quotes because there's medical debate over whether that is actually a fetal heartbeat. For one thing, at that stage, most physicians call it an embryo and not a fetus. And also there's a lot, physicians who specialize in women's reproductive health say that the sound that you hear that is the quote unquote heartbeat is not actually a heartbeat, because the embryo's heart has not developed the valves necessary to pump blood, that what you're actually hearing is this electrical image from the ultrasound machine. But regardless, it clearly is getting at pre-viability abortions, since viability is generally considered somewhere about 24 to 28 weeks in pregnancy. And this law bans abortions that are, 6 weeks pregnancy, or because the way they measure pregnancy is interesting too, because they measure pregnancy not from the date of conception, which is what a lot of us who aren't versed in this would think. Pregnancy is actually kind of measured from the first date of a woman's last menstrual period, which means it's really more shifting to 3 to 4 weeks after conception, which makes it even more difficult for a woman to know she's pregnant. We aren't talking, months, we're talking weeks, maybe a week or two after a missed period. And, women's cycles aren't always regular, so that makes it much more difficult for women than even an initial glance at it would, you would think. But the law, if you can't pose a undue burden or place a substantial obstacle in the way of a woman who's seeking an abortion, clearly a ban like this is doing that. And it has actually had a huge effect on the ability of women to get abortions in Texas. The vast majority of abortion providers on the day that SB 8 became law stopped providing abortion care to women whose pregnancies had exceeded that 6-week time point. Some of them quit providing abortion care entirely, and they've completely shut down. Others, it's even gone so far as to affect other reproductive health decisions. There's a lot of doctors who are very wary of being sued, so they're concerned about things about terminating a non-viable pregnancy because they're worried someone will sue them. They're worried about providing care to a woman who's suffering a miscarriage because what if somebody sues? Now, this is stuff that SB 8 is not actually banning, but the fear of a lawsuit, as you know, is a huge thing. Also, it's made insurance premiums for OBGYNs practicing in the state of Texas skyrocket, which is going to impact all women's reproductive health, those who want to have abortions, those who want to have children. It's going to hurt all Texas women, and in fact is doing so. So it's got even more of an impact, even if you are not particularly pro-choice or pro-abortion rights, it can still be impacting you. One thing, this law is unique in the abortion law landscape in that it is not being enforced by the state of Texas. As Professor Rosen described, it can be enforced by private lawsuits, which makes it very unique. And the reason the state of Texas chose this kind of way of doing it is because the normal way reproductive health advocates and abortion providers challenge restrictive abortion laws is they try to go get an injunction to prevent the law from going into effect. And so but when the state of Texas is not enforcing the law, the court has said that there's no one to get an injunction against. They tried to enjoin the entire Texas court system in the case Whole Woman's Health that Professor Rosen described, but that the Supreme Court said, no, can't do that one. So that's why the law has gone into effect, even though it is clearly unconstitutional. You're forcing abortion providers into kind of this defensive posture to where in order to challenge the law, they have to perform an abortion, be sued, and then challenge it as a defense, which means that for months, Texas women are unable to get the abortion care that they need and desire in this state. It's posing a huge burden on women. You have to travel out of state to get an abortion if you are past this, magical 5 or 6 week time period. And this hurts poor women the most. It hurts women of color the most, who are disproportionately poor in this state, because you have to take the time and expense to take time off of work, to travel out of state, hundreds of miles perhaps. And so it's just burdening their choices more and more to make it really impossible. You're faced with either you have to travel out of state and spend extra money, you have to remain pregnant when you wish you not to, or you have to go try to get some kind of unmedically supervised abortion, and which will only lead to more women being hurt. So it's having a big impact. But it's not just abortion that this law could impact, because really, when you think about this enforcement mechanism of private lawsuits and turning individual citizens into bounty hunters kind of on their neighbors and friends, that there's really no reason why other states could not do the same thing for other constitutional rights that maybe they don't like that much. There's nothing to stop a state like, say, California, which is more liberal and less gun friendly than we are in Texas, to say something like, well, we're going to ban guns, but it's going to be enforced through private lawsuit, or in many other things. And you could end up with kind of this patchwork of constitutional rights across the country as to what is actually, being allowed in the state based on these private lawsuits and the fear of being sued. So it's really going to have a big impact, whether or not, even beyond the abortion context, which is huge enough. And it's really Texas usurping the federal courts' role in defining, you know, just in deciding the constitutionality of things. They're taking this on for themselves, and they're kind of taking that, you know, it's so if you're pro-federalism, you're pro the federal government doing some things and state doing other things, the state's kind of stepping into it here, and they're taking on that role. And there's nothing to stop other states from enacting, you know, similar laws for abortion. I know some states and some representatives have already said, oh, well, this is working. Florida, we're next. And we're next. Oklahoma, we want to get on this too. And so it could happen in a lot of states, and then it could happen for other constitutional rights. So it's a really, really important thing to understand, because even, you know, abortion is, of course, an important right, but it goes beyond that as well.
Thank you, Professor Harris. I already have about 16 technical questions about constitutionality and precedent and all of that, but I'm going to save them for a little bit and introduce our third speaker, Adam Winkler, the Connell Professor of Law at the UCLA School of Law. He's a specialist in constitutional law, the Supreme Court, and gun policy. He wrote an absolutely gripping book on the Citizens United case, and so much more fit into that, titled "We the Corporations: How American Businesses Won Their Civil Rights," which won the Scribes Book Award from the American Society of Legal Writers. It was a finalist for many other honors, including the National Book Award. His earlier book on the Second Amendment, Gunfight: The Battle Over the Right to Bear Arms in America, did not win any awards, but was once the subject of a question on Jeopardy! Professor Winkler's scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments. He'll be addressing the second tomorrow. His writing has appeared in the New York Times, Wall Street Journal, Atlantic, Slate, The New Republic, lots of places. Before joining the UCLA law school faculty, he clerked on the U.S. Court of Appeals for the Ninth Circuit and practiced law privately in Los Angeles. He is one of the 20 most cited legal scholars in judicial opinions today. So we're very happy that he's spending this academic year as a Phi Beta Kappa visiting scholar. And we're looking forward to his talk tomorrow, 4 p.m. on the Second Amendment at the Crossroads. Professor Winkler will discuss how the battle over guns has shaped America since the earliest days, how the Supreme Court, as currently constituted, is likely to weigh in. Professor Winkler?
Well, thank you so much for that lovely introduction. It's a real honor to be here. I'm really proud to be a Phi Beta Kappa visiting scholar and get the chance to come visit different universities and give talks. And I only wish that we were able to do this visit in person, having the chance to have sort of informal chats with the faculty and the students and the staff over at Texas Tech really would have made this week a lot better and a lot more fun. So I'm sorry that we can't do it in person in this COVID era, but super happy to be with you. Thank you to Professor Maloney, Professor Tortorelli, Professor Rosen, and Professor Harris, all for coming and joining me on this for this presentation. So, I'm going to talk a little bit about the Dobbs case that Professor Rosen mentioned earlier. This is the big case coming up before the Supreme Court. Arguments going to be heard in December. And it asks whether Roe versus Wade shall remain the law of the land. Roe not only held that the Constitution guarantees the right to choose abortion, but said that prior to the fetus becoming viable outside of the womb, the state just did not have any particularly powerful interests to justify regulation of the choice of the pregnant person to abort the fetus before viability. But Mississippi's law, which is the law that's at issue in the Supreme Court case, not Texas's SB 8, but Mississippi's law prohibits most abortions after 15 weeks, which is long before a fetus is actually viable. And I don't think there's any real doubt that if the Mississippi case had come up to the Supreme Court a few years ago, the Mississippi law would have been swiftly overturned. The Supreme Court, however, over the last few years has gained 3 new justices. The personnel on the court has changed. Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, all appointed by former President Donald Trump. And each of those 3 justices is likely to be a vote to uphold the Mississippi law and to curtail abortion rights. And I guess the question on everyone's mind is, will the Supreme Court actually overturn Roe versus Wade? And I think, first of all, it's worth recognizing that Roe versus Wade has already been overturned in some ways. Yes, formally it's still on the books and women do have the formal right to choose abortion. But in the 1992 case of Planned Parenthood versus Casey, the court said, we'll uphold the core holding of Roe versus Wade, that there is a right to choose abortion, while at the same time permitting states far more leeway to restrict abortion. And since Casey was decided, courts have upheld laws requiring women to wait up to 48 hours after seeing their abortion provider before they can obtain an abortion. The courts have upheld bans on late-term abortion procedures, upheld laws requiring pregnant people seeking abortion to undergo state-approved counseling first. And the effect of Casey was really significant. Today, there are half as many abortion clinics in the United States as there were in the mid-1990s. In 6 states today, there's only a single abortion provider in the entire state. This includes, by the way, Missouri, a state with 6 million people, 2 major cities, but only a single abortion clinic. So when we think about whether Roe is going to be overturned, we should recognize it's already been pruned back pretty significantly before this Mississippi case comes up. No one really knows the future, whether the justices are going to strike Roe down in its entirety or just allow even more restrictions to be put in place. We'll just have to wait and see. I suspect that there's a pretty good chance that the court's going to overturn Roe in its entirety. I don't think that the Supreme Court in recent years has been particularly shy about striking down laws or overturning precedents. Some years back, the court struck down a key provision of the Voting Rights Act of 1965, widely regarded by historians as one of the most important and effective civil rights laws in all of American history. And the court has struck down certain provisions, gutted other provisions of that historic act. In 2018, the court overturned another landmark decision in the area of labor unions and their ability to collect fees, overturning a precedent that had been reaffirmed multiple times since it was first put on the books in the 1970s. Now, and I think that the Texas case, the SB 8, and the court's refusal to step in or inaction on SB 8 when it came before the Supreme Court is at least a signal, I think, that the justices, or at least a majority of the justices, don't value abortion rights as much as they might value some other rights, and are willing to allow these restrictions to go into effect, despite the fact that what Texas has done is kind of a scheme to get around federal court jurisdiction. Many opponents of SB 8 said that the law was unprecedented in that it empowered private individuals, but not the state itself, to enforce the law. But it's hardly the first time a state has tried to restrict constitutional rights by outsourcing the job to private parties. In fact, the Supreme Court has confronted this issue numerous times before, but in the past, the justices always saw through it and put a stop to the effort. We don't even have to look any farther than Texas. In a series of cases between 1920 and 1944, known as the white primary cases, the Supreme Court refused to allow Texas to deny African Americans and Mexican Americans the right to vote by outsourcing control over primary elections. Because the Democratic Party dominated the political systems of Texas and other southern states after Reconstruction, the state and local primary elections for the Democratic Party usually determined the candidate that would win in the general election. And Texas first sought to exclude racial minorities from the Democratic primary by passing a law prohibiting minorities from participating, only to have the Supreme Court step in and declare that law unconstitutional, a violation of the right to vote and equal protection of the laws. Then Texas decided to do kind of what Texas did with SB 8. It passed a new law that gave the power to determine who participates in party primaries to the political parties themselves and their executive committees. Again, private entities that wouldn't be directly covered by the Constitution. But the Supreme Court saw through it and struck down that law as well, not standing by idly while Texas outsourced control over who participated in party primary elections. Also, states seeking to avoid desegregating their public schools in the wake of the Supreme Court's decision in Brown versus Board of Education also tried this kind of outsourcing maneuver. For instance, Prince Edward County School District in Virginia was ordered by a court to desegregate, and the school district, instead of desegregating, decided to close all of its public schools and outsource education to private schools. White students had the option to attend private schools, which as private actors were not required to desegregate. And the state provided tuition grants for those students to pay for the private schools. This lasted 5 years until the Supreme Court stepped in and once again struck down the policy as a scheme to deny racial minorities their equal rights. So I don't think SB 8, the Texas abortion law, is really totally unprecedented in how it outsources the denial of constitutional rights. But what is unusual is that in the past, the Supreme Court's generally said, we're not going to allow states to get away with that. And now the Supreme Court is suggesting that it's, if not okay, that the court's at least not going to rush to step in and put an end to Texas's effort. So I think that is a sign of what we might expect from the court overturning Roe versus Wade. I also want to just say a quick couple words about what the effect of overturning Roe versus Wade might have on American politics and on the long American debate over the constitutional right to choose. Some people think, well, if the Supreme Court overturns Roe, well, then the political waters that have been roiled by abortion for the past half century will finally calm. But I don't think so. I think that reversing Roe will likely have the opposite result, supercharging the political debate over access to reproductive care. Without Roe in place, the legal landscape of abortion will have to be renegotiated in state after state after state. Some states are going to protect abortion easily. Some states are going to restrict abortion easily. But in the majority of states, there's going to be real political battles over what the law should be and what kinds of restrictions can be put in place. Also, you often hear that if Roe is overturned, it will just leave the issue of abortion to the states. I don't believe that's accurate. I believe that proponents of abortion rights, for example, would seek to protect access for all women through a federal law protecting the right to choose nationwide. In fact, after the Supreme Court declined to hear a challenge to SB 8, Democrats in the House passed the Women's Health Protection Act, which would guarantee the right to abortion nationwide. Now, this law is not going to go into effect. It doesn't have the votes to get through the Senate, but it would have the effect of overturning many of these abortion restrictions enacted at the state level, again, through a federal law. And I think similarly, foes of abortion who believe the practice is murder are going to want to protect fetuses nationwide. And I think that we can expect that if Republicans gain control of both houses of Congress and the presidency, they'll pursue a federal bill to outlaw abortion nationwide. And I think abortion politics may also be supercharged if, as some political scientists predict, overturning Roe leads to a renewed and rejuvenated political movement for women's rights. For years, political scientists have said that Roe versus Wade itself led to a huge political backlash that deeply impacted American politics. Roe was seen as sort of the watershed moment in the formation of the organized Christian right in America, which has proven to be one of the most powerful and effective political groups in American politics over the last 40 years. And it's certainly possible that if Roe is overturned, it could lead to a similar kind of backlash and a political mobilization of progressives and moderates who support abortion rights and other issues on the sort of the left side of the spectrum. And so I think that a Supreme Court decision in the upcoming Dobbs case that overturns Roe in its entirety could, like Roe itself, spark a political backlash and energize voters. It may not take us long to find out. The Supreme Court's decision in the Dobbs case is expected in the spring of 2022, just in time to have an impact on the midterm elections. And so it may not be long before we learn if overturning Roe calms the political waters over abortion or hits American politics like a tidal wave.
Whoa. So a lot happening. Thank you so much, Professor Winkler. I've only got one question coming in through the Q&A link so far, but I assume that some of you may have clarifying questions or concerns for each other.
I have one. Even if, for example, the district court's decision with respect to the United States' lawsuit is upheld, until Dobbs is decided, isn't there sort of Damocles over abortion providers with the retroactive provision in the law, making them reluctant to provide abortions until at least Dobbs settles the issue one way or the other? Of course, if Dobbs overrules Roe, the Texas law is academic. I mean, Texas will probably just ban abortion, but what do you think about the period between, for example, an injunction and the Dobbs decision? Wouldn't doctors be reluctant to provide abortions for fear that they could be held responsible for abortions, even while those abortions were constitutionally protected?
I think many doctors would be reluctant. As you said, the district court did issue an injunction, but the Fifth Circuit has stayed that to where the law is back in effect. It was, these abortion rights advocates were celebrating for about a whole 48 hours. And then there was it's back in effect. But even if it, was appealed up to the Supreme Court and say this time the Supreme Court did something different, although I don't think that'll probably happen, or, a fuller hearing of it. I do think until Dobbs has decided there is this just kind of like pall over abortion rights, particularly in Texas where we have SB 8. And, so I do think that is kind of the background of all of this. And that's why, people were looking at what the Supreme Court did so much in this kind of just one little, it wasn't the opinion they issued in SB 8 was not a real opinion. There was no oral argument. It was one of those, what they call the shadow docket rulings. But everyone was kind of looking at it as an indication of what will happen in June when the Dobbs case is decided. So I do think that, that's the background that we're all kind of waiting to see what will happen and trying to predict. And it does make it much harder for abortion providers to provide the care that is needed or desired when they don't know what will happen. I know some abortion clinics have said that if there's an injunction, they're back to providing abortions. There's some who've committed to taking that stance that if there is an injunction against the law, they will be providing abortions regardless of, whatever may happen. And this whole thing about, retroactive, enforcement of if it's later, they say that you can ban abortion. They've said they'll do it, but I think there will be a good amount of them who are very concerned with this potential ruinous liability, where they can be sued by anyone and everyone. There was a doctor in San Antonio who bravely did perform an abortion that would violate SB 8. He wrote an article, or not an editorial, sorry, in the Washington Post saying, I violated SB 8. Here's why, come and get me. And he has been sued, interestingly enough, by 2 out-of-state, former attorneys. So, it's very interesting. It's also SB 8, this enforcement mechanism is very unpopular. It's unpopular even amongst many pro-life people. There's some pro-life people who obviously feel that, well, anything you can do to save potential human life is worth it. But there's also some who really don't like this, kind of turning everyone into a tattletale or, a rat or whatever you want to call it. And it is, kind of, because it is a unique way of looking. It's not the state, it's not the prosecutor coming and getting somebody. It's what everyone's used to when they think of criminal laws. They're not used to thinking that someone who has no connection to the woman, her potential fetus, someone who, I'm this doctor in San Antonio who violated SB 8 is being sued by a former attorney, also former criminal, who lives in Arkansas. He doesn't have any connection to this woman or her fetus, and yet he's suing. And so I think that is distasteful to a lot of people, because you wonder what they're just trying to get that $10,000, and that doesn't seem right to many people. So it's, this way of going about doing things in order to escape federal review is having some very interesting consequences.
As we would have predicted, of course. Thank you. Professor Winkler, did you want to expand I personally, I have a question because I am fascinated by the idea of a law that is retroactive. I mean, in the Dobbs thing, have courts respected retroactive laws in the past? This is my ignorance of law speaking.
Sometimes retroactive laws are acceptable depending on the context. But what you're really getting at, I think, highlights that there's a potential significant due process problem with SB 8. In that people can be following the governing law of the land and yet still be liable for committing or assisting one of these abortions. And so it is a significant due process problem. Part of the principles of due process is that people are entitled to know what the law is in advance, and so that they can shape their behavior accordingly, and not be caught having done something wrong when it wasn't actually illegal at the time. And SB 8 sort of turns that idea on its head and says, hey, we're telling you you're going to be liable for this come hell or high water. And it doesn't matter whether you have a court opinion, say a Fifth Circuit opinion, if the Fifth Circuit had come in and allowed this temporary ban or allowed the injunction to stand that would have put a halt to the 6-week abortion ban under SB 8, and someone performed an abortion, then they could still be held liable if that gets overturned by the Supreme Court in 2 years' time. I think significant due process problems might be raised by SB 8. And I have a feeling that that SB 8, if some of its provisions are ultimately upheld, is likely to spawn a whole wave of different lawsuits raising different challenges to different aspects of the law. We've focused on the 6-week abortion part because that's really what's uniting this particular panel. But as a matter of constitutional law and due process, it raises a whole bunch of other questions as well.
Indeed. And questions are being raised all over. I have for Professor Harris a kind of technical question about where pharmaceutical abortifacients fit into all of this. Do you have anything to say about, or do you understand how chemical abortions fit?
Well, Texas just passed another new restrictive abortion law, getting at medical abortions, what you're referring to, pharmacy, where you take drugs in order to cause an abortion, which is what pharmaceutical or medical abortion is. They passed another law just recently, very recently, banning all out-of-state importation of those, to where people were going, oh, well, don't worry, Texas women, you can get them, you can order your abortion drugs online and it'll be okay. No, it won't be, because the legislature is on that too. I think that is banned after 7 weeks of pregnancy, or as I said, more like really 4 to 5 when you are actually talking about conception, which is what most people think of when they think of pregnancy. They don't think of the first day of your last period before you became pregnant, those are being banned too. It's not just the kind of surgical abortion where you go into an abortion provider and have a procedure. The medical abortions where you take a dose of drugs in order to cause an abortion are also being banned.
The question does kind of point out, by the way, that's just the future of what abortion is going to look like in America. The percentage of abortions that are now done through medication, through pharmaceuticals, has just been steadily climbing for the last 10 years. And it's now about half. The last I saw was about half of abortions in America are through medical abortions rather than surgical abortions. And I think that's only going to increase. And I think, well, if the court overturns Roe versus Wade, or if we see more restrictions in place like Texas, we are going to see the development of more and more international sources for medication abortion, for these abortifacients. The world, once you go online, it becomes very difficult to control what information people get. Texas might outlaw the importation of various kinds of things, and Texas is outlawing of importation of medical abortion pills, for instance. will be effective, I think, in restricting other American organizations. Planned Parenthood in Los Angeles is not going to send medical abortion pills to women in Texas because Planned Parenthood could be subject to process in Texas. But we're going to see the rise of international consortiums of organizations that are underground organizations that are going to be providing these pills to people. And it's going to create a world in which we're still having lots of abortion, but the abortions we have are less regulated than ever, where the pills that people are taking are less likely to be guaranteed to be safe and effective for their intended use. And we're going to be putting women, although medical abortions are a hell of a lot safer than the old wire hanger abortions of the back alley that we heard our grandparents and parents talk about. They're much safer than that, so that's good news. But it's still going to leave women in undergoing medical care that can be significant, that can have side effects, that can cause, that can have complications, but doing it underground for fear of running into real trouble. And so I do think it's sort of a highlight about how we can expect abortion to occur in the future. The more restrictions you have, it's not going to eliminate the desire of people to get abortion. And the technology of the internet and the World Wide Web provides us the mechanism by which we can do that. Texas can't really control the mails, right? That's controlled by the federal government, and the federal government has too much mail to search. So this is not going to, we can ban the importation of these medical abortions, but in the long run, it's probably not going to be nearly as effective as foes of abortion really wish it to be.
I
Yes.
think that's, sorry.
Go ahead, please. No, please.
I think that's an excellent point, Professor Winkler. And it's often said that banning abortion doesn't actually ban abortion, it bans safe abortion. And that is something that is a real big concern with any of these restrictive abortion laws, is that there's still going to be women who have unplanned pregnancies that they're desiring to terminate, and they will find a way to terminate them. And it'll just be a more unsafe, unregulated way. So whether that be through kind of, some kind of international company that, or some kind of not official registered medical company. It's not Planned Parenthood. It's not CVS, somebody, and that was worried about liability. It's something else. And then you have to worry, what are you taking? Are you taking something that's actually safe or not? And so I think that's a good point, that, all it is really doing is hurting the ability to get a safe abortion, not, banning abortions, and as they say is the goal.
We are talking about medical procedures and healthcare, really. And so I want to read word for word a question submitted from the audience. Where does the burden of proof lie? If an accusation is made toward a woman, how does she prove her innocence? Would she be compelled to provide blood work results or physical examination results? Wouldn't this be a violation of her medical rights? Who'd like to address this?
Well, a woman can't be sued under the act. They're not subject to lawsuit. It's only the abortion providers and those who aid and abet in the abortion. So they will not be sued.
That actually ties into the next question about how much risk there is for any private citizen discussing abortion with anyone who might end up getting an abortion sometime in the future. Since the new law allows any private citizen to sue anyone who aids or abets, does that mean, I mean, how broadly can we worry about that being construed?
There was a letter submitted to the state legislature before SB 8 passed by a group of attorneys. I forget how many, 270 or so attorneys, raising that very issue. What if a doctor advises a woman, maybe you should think about an abortion, or a family member? The attorneys considered that to fall within the aiding and abetting provision. So it could be quite broad. I've been asked questions by the press as to whether that includes the Uber driver that drives the woman to the abortion clinic, if he knows that she's going there to get an abortion. It could be a pretty wide net if someone wants to make a lot of money, assuming this law is sustained, which I ultimately think it will not be, assuming Roe and Casey are upheld.
But it does point to sort of an odd thing about this law, right? So if I'm a pregnant person and I go procure an abortion that's beyond the 6-week margin here, as the patient, I cannot be sued. The law is very clear that I am not a proper subject to be sued. But if I take an Uber there and the Uber driver doesn't even know where we're going, I have him drop me off a block away. Nonetheless, he has assisted under the terms of this law, very possibly, the procurement of an abortion and could be liable for $10,000, even though no particular knowledge requirement, no particular understanding of what's happening. And me, the pregnant person who goes and gets the abortion, is not liable at all. I have not participated in the aiding or abetting of the assistance of an abortion. And I think that sort of reveals sort of a real tension here in the efforts to regulate abortion, because there really is a concerted effort to avoid imposing liability on the pregnant person. And I think we have to ask what that tells us about what we think of that pregnant person's moral culpability for getting an abortion. Apparently the moral culpability is not that great because there's no liability that we're attaching to that action or that behavior. And so it's really kind of an odd bill in that, although it's commonplace in that we see a lot of restrictions on abortion that exempt the actual pregnant person from being liable. And indeed, some states that have criminalized abortion, now those laws are held in abeyance because of Roe versus Wade, but have them on their books. Some of those laws will, when they go into are designed to go into effect the moment Roe is overturned, and they criminalize abortion. But most of them criminalize not the pregnant person and don't make the pregnant person a subject of criminal prosecution. In fact, most of those laws explicitly exempt the pregnant person, the person who is the real agent, the person who's making the decision, the person who's choosing to actually get the abortion, and instead impose liability on doctors and nurses who help provide those services. And I just think it's just sort of an odd way of thinking about the law, that the real person responsible is exempted from liability, but the Uber driver or the nurse or doctor doing their job is somehow held liable.
I might also point out, under the Lubbock ordinance, the person who gets the abortion can sue for damages because the pregnancy was aborted. The person who the pregnant person who gets the abortion is a named plaintiff under the ordinance.
I just want to address one thing, that because it is interesting that a lot of abortion laws do not target the women. And this was actually done because they've done a lot of polling, and that going after women who are getting an abortion is proved unpopular, whereas laws that are targeting the abortion providers, more people support those. So it is a strategy of the pro-life or anti-abortion, whatever you prefer to call them, movement to go after the doctors, to go after the providers instead of the women. That's seen in a lot of laws. If you've heard of TRAP laws, targeted regulation of abortion providers, where they make abortion providers follow all these very strict rules. It's done it to get at them. They do not want to really prosecute the women. I saw a question in the chat that was interesting about what's next. Are they potentially going to go after Plan B or the birth control pill? And a lot of people say, well, just get on the pill and you won't have to worry about abortions. And I think that there are some people who do want to go after those, and because the constitutional argument for abortion, the reason announced in Roe versus Wade, that was based on Griswold versus Connecticut, which was the birth control case. So I think that you can see how that fear is not unjustified. The person who was the architect of SB 8 and actually the Lubbock ordinance as well, John Mitchell, an attorney, he wrote in an amicus brief in the Dobbs case where he hints that, Griswold versus Connecticut might, that should also go, because that's the same kind of substantive due process argument of Roe versus Wade. This stuff really isn't strictly in the Constitution, in the text of the Constitution. So I don't think those are unjustified concerns. I think obviously birth control is a more popular thing than abortion. So the political realities of that, I don't know how that would happen, what would happen, but I do think it is something, you know, to be interested in. It's not crazy.
Oh, I agree. It's definitely not crazy. I mean, I have heard arguments made about different forms of birth control and which ones involve an actual fertilized ovum. So
And
it's not crazy.
I would also say that SB8 defines pregnancy as fertilization, not implantation, which if it's a fertilized egg, you're pregnant. And there's many just a regular birth control pill also, as well as preventing a release of an egg, prevents implantation, as do many other kinds of birth control. IUDs prevent implantation, etc. So you start wondering, well, if fertilization is life, then what about these various methods of birth control that prevent implantation? Would those also be able to be banned at some point? Obviously that wouldn't fall under SB8 because of the 6-week fetal heartbeat thing, but in a more expansive pro-life anti-abortion law, you can see how it might.
Yeah. So I think I know the answer to this next question, but I'm not sure because it's a little muddy. If the court does overturn Roe, what do you think will be the constitutional basis of their argument?
I'm happy to jump in on this one. So I think what the court will say, and what conservative judicial theorists have been saying and judges have been saying for 40, almost 50 years since Roe was decided, which was that Roe was undecided, that Roe was judicial activism, that it was the court reading rights into the text of the Constitution. The text of the Constitution does not include a clear right to privacy, certainly not a right to sexual privacy, a right to be secure from certain kinds of searches and seizures under the Fourth Amendment. But other than that, really no real protection for sexual privacy. The framers of the Constitution, or even the drafters and ratifiers of the 14th Amendment that makes the Constitution, or much of the Constitution, applicable to the states and local governments, they weren't thinking about birth control. They weren't trying to protect birth control. They weren't trying to protect necessarily abortion either. This was not on their minds, right? And so the argument against Roe versus Wade is that the court is reading rights that are not in the text of the Constitution into the text of the Constitution. And that's why I think that I agree with Professor Harris's point about it may not be the same kind of popular demands for overturning birth control or the right to privacy more generally. But it's not just a political question, it becomes a judicial question. And if the court says that Roe was judicial activism because it read rights into the Constitution, someone's going to challenge Griswold and the ruling that says birth control is protected by the Constitution, because that's nowhere more protected in the Constitution than abortion is. And it's the same line of cases. And I think there'll be an effort to overturn a case called Lawrence versus Texas, decided in another case out of Texas. Texas is really, at the forefront of American constitutional rights all the time here. I don't know what's going on. But that's another case out of Texas that said that same-sex couples have a right to sexual intimacy and can't be criminally prosecuted for having sexual intimacy with someone of the same sex. I think that's going to be subject that is something that people will go and try to go to court and overturn. And see, that's the thing about judicial doctrine. It's not just about a political movement. Is once there's a doctrine that's built into the law, anyone can use it. Anyone can go to court and challenge Griswold. Anyone can go to court and challenge Lawrence against Texas. And so the leaders of the anti-abortion movement might not be the ones at the forefront of the effort to restrict birth control, or they may be. But even if they're not, they don't have to be. The law will be open to any challenger, and the doctrine is equally applicable to all. And so it's hard to know what constitutional argument the court could make that would say Roe versus Wade is wrongly decided and must be overturned, but that would secure and safeguard cases like Lawrence against Texas or Griswold versus Connecticut. So I think sexual privacy is facing a really uncertain future in the Supreme Court if the court overturns Roe.
Okay, yeah, I was thinking more in terms of states' rights and just the ability of Texans to decide for themselves, something that is a moral decision, medical decision mixed altogether.
Well, I think that's right. I don't think I don't think the two ideas are totally in opposition, but it's not just because of state rights that the court's gonna overturn Roe versus Wade. States don't have rights to regulate individual fundamental rights. And so the court has to say that there's no constitutional right first before it leaves it to the state. And I also don't think, as I mentioned in my primary comments, that it's not really going to be just a matter of left to the states. This battle will be fought at the federal level, like every other important battle is. And that if there's not federal regulation on abortion one way or the other, it's only because neither side can get the votes in Congress to do it, because this won't be just a state issue.
As I look through the comments, overturning Roe would unsettle a massive body of jurisprudence and would create a thicket of other issues, especially as regards supremacy in the same stroke. As not a lawyer, I don't understand.
I can say
wouldn't-
something on this, which is just, I mean, I think that's what we're really kind of what I was kind of saying, right? It's going to create a thicket of issues if you overturn Roe versus Wade. And that could be enough to prevent the court from doing it. I don't think it's 100% certain that the court's going to overturn Roe versus Wade. I don't think the justices are sitting in their back room saying, I can't wait to do it. Well, some of them might be, but some of them maybe.
There's a recording of this, right?
Yeah, that's okay. I think some of the ones who are scheming in that way are probably pretty proud of it. So I think it will upset a massive body of jurisprudence and lead to a whole new set of legal questions about abortion and about the different kinds of laws that are going to go into place. And I think there are some justices who will be concerned about that. One of the concerns that the courts and judges look at when deciding whether to overturn precedent, whether to depart from the principle of stare decisis, Latin term for basically you should stick to precedent, even if you think it's wrongly decided, because the thing decided is itself a value to the law, because people have to organize their affairs in reliance on these legal pronouncements. And so I think there might be some justices, maybe Chief Justice John Roberts will be less likely to join a majority of justices to overturn Roe versus Wade for fear of sort of the impact it was going to have and reverberate through jurisprudence in other areas of law and how unsettling it might be. But I get the feeling there's a good handful of justices who really don't care about that. And as Neil Gorsuch said in a different case, it doesn't really matter whether there's upheaval from a judicial decision. The court's job is to get the law right. And if there's an upheaval, let legislators step in and they can deal with it.
I would agree. I think that Justice Roberts may be animated a little more. Chief Justice Roberts may be a little more concerned with stare decisis and the impact that this would have on a wider body of jurisprudence. But similarly, some of the justices who might be looking to overturn Roe might also think that some of these other things should be overturned, that there really aren't these rights in the text of the Constitution. When you talk about this kind of strict textualist reading of the Constitution, that there really aren't these rights written out. And I think that they would not be horribly upset if they said, well, there's no, constitutional right to birth control or no constitutional right to private sexual activity, outside of marriage or in a homosexual relationship. So I think that, well, some people might go, well, I don't like abortion because that's, maybe a life, or it is life, if that's your belief. But I like this. I think that when you're looking at it from a legal perspective of what these rights are these rights really in the Constitution or not, that I think some of the justices who believe that the right to abortion is not in the Constitution would also think these rights are not in the Constitution. So they would not have that concern with those potentially being ruled that that's not protected by the Constitution as well.
Oh, here's I think a quick question. Has 50 years of precedent ever been overturned to take a right away instead of expand it in the past? And immediately I'm thinking of prohibition, but we're really talking about taking away rights rather than expanding rights, and that seems rare.
It is rare, but actually not unprecedented. Maybe not 50 years. Maybe I think I can name one that's 40 years, about 40 years, but which was in the around between 1890 and 1937, a period in the Supreme Court's history known as the Lochner era. The Supreme Court read the Due Process Clause, the same clause that the court reads the right to choose abortion into, read that clause to protect a liberty of contract, a liberty that people had to negotiate freely with their employers. And the court said that because of this liberty of contract, states could not impose, for instance, minimum wage or maximum hour laws. And the argument was, well, if someone wants to negotiate and sell their labor for less than minimum wage, they have a constitutional right to do that. If someone wants to sell their labor and agree to work for 100 hours a week rather than the 60 hours a week that the state puts as a cap, well, that's their freedom. That's their individual liberty. So that is a precedent that will be probably considered by the court. And I imagine that if the court overturns Roe versus Wade, there'll be some justices who point out the Lochner era and how many people think it was important for the court to overturn the freedom of contract, that it was wrongly decided and it caused a whole bunch of problems in preventing the government from regulating business affairs and regulating the economy. And protecting vulnerable workers, and so it was overturned. And so we have seen that's a high-profile example of a right that was an individual right that gave people liberty to do something, and gave them immunity to a certain extent from government regulation. That was subsequently overturned. That took away that right. That gave the government more power to regulate. So there are examples. There are some other ones, perhaps even more controversial. If you think about, for instance, slavery, it was considered the property owner's right to own a slave. And of course, we ended slavery and ended that right. Now, I think that's a bad analogy for a whole bunch of reasons, but certainly the liberty of contract is a more direct and obvious historical precedent for overturning Roe.
I like the parallel. So let's see, other questions in the chat or in the Q&A. Feel free to click on either of those links and get to me. Do the three of you have any unresolved discussions to address to each other?
I'd just like to point something out that came up, I believe, in the United States' complaint. And that is the standing issue, in part, was based upon federal interest in gaining an abortion. I believe it may have been the complaint that raised the issue about DOD, Department of Defense, and military hospitals. One thing I would point out is that our big military installations in Texas are exclusively federal jurisdiction, and it's doubtful that the SB 8 would apply. In any event, if someone were to sue a federal official or perhaps a contractor, if they fall under the government contractor defense, they're going to find themselves immediately in federal court under the federal official removal statute, which I think is something that certainly the authors of SB 8 don't want. I mean, that will trigger immediate federal district court review.
Excellent. Thank you for clarifications. Wow. Yeah, I hadn't even considered federal versus state. Anyway.
I think one other comment I'll just make is I think it's going to be really interesting to see what happens with SB 8 going forward, not just because of the Dobbs case. You've seen like there's proposals in other states to adopt an SB 8 like mechanism, a private enforcement mechanism, so that sort of outsourcing the denial of constitutional rights to private parties. We've seen some states talk about doing this in the abortion context, just like Texas did. We've also we've also seen at least activists talk about maybe, and I think Professor Harris mentioned this earlier, a state like California could restrict access to firearms in this way. And I think one of the interesting things to look at is whether SB 8 is really that kind of a viable mechanism to deny constitutional rights. And it's been successful so far in Texas, but only for a few months. And I'm not sure that it would be, it's going to last a lot longer. We'll have to see. And obviously what the Supreme Court does in the Dobbs case puts everything up in the air. But the mechanism of making it a private enforcement action is really only a temporary stop on judicial review, right? It made it so that made it hard for abortion providers to get pre-enforcement a pre-enforcement injunction against the law. So before the law was enforced, usually you would get an injunction. I think Professor Harris talked about this in her comments earlier. You'd usually just sue the state and get an injunction and stop the abortion law from being enforced. That's what happened, for instance, in Mississippi, right? They went and said, you passed this law banning abortion after 15 weeks. We'll just sue the day it's going to go into effect, get an injunction. The law is clearly unconstitutional. And here the court, the Supreme Court didn't say SB 8 is great, it's lovely, it's constitutional. It said, well, this is not a proper case for us to step in, that no individual who has a personal stake is involved on the other side. You have the abortion providers, well, they have a stake, but you need both sides to have a stake in the outcome. And so they were kind of searching for someone to sue. But like we say, the United States has now stepped in. That avoids the problem that was identified and avoided by SB 8. We now have private individuals, as we noted, from out of state that have sued the doctor who wrote that op-ed. So we're getting the lawsuits. There's going to be proper parties before the courts in those lawsuits. And the underlying question of whether we can restrict abortion in this way is going to be answered by the courts relatively soon. I don't know exactly when, but I think that while it's a very, very dastardly and effective means of shutting down abortion for a short time, I'm not confident that it's actually a viable mechanism in the long run for shutting down abortion rights or other constitutional rights. And so one of the things I'm most interested to see is how long does that take? And if I'm right, that eventually it's going to be struck down for violating the basic constitutional doctrine of abortion, whether this is the kind of mechanism that other states will copy, even if it's just a delay mechanism and not really a substantive mechanism that's going to allow them to violate rights going forward.
But of course, the land war tactics of this are obvious as well. If you can close down clinics because they can't stay open in the meantime while the courts are figuring things out, there you go.
Well, state court judges too are bound by Roe versus Wade. I mean, they're bound by the Constitution. So when these things get into state court judges, if they do what they're supposed to do, will find the SB 8 or the Lubbock Sanctuary City Ordinance to be unconstitutional. They will not enforce it, or they should not enforce it.
I would agree that this is kind of a temporary measure to limit abortion, because eventually people will be able to assert abortion rights, assuming they still exist after next June, which is a big assumption, as we've talked about. Supreme Court will be deciding that case, but they'll be able to assert those constitutional rights eventually. But for the women who are currently facing an unplanned pregnancy or an unwanted pregnancy in the state of Texas and are now being forced to travel hundreds of miles, take days off of work, potentially remain pregnant when they don't want to, or take maybe some medicine that they aren't 100% sure of the province of, they are suffering right now. And so while eventually maybe nice, but as they said in Roe versus Wade, pregnancy, it's a time sensitive manner. And obviously if you're a pregnant person in Texas right now, and you're wishing to terminate your pregnancy, well, what happens in a year or two might be good for somebody else, but it's not good for you. So I agree that it is kind of a delay thing, but it is having a huge impact on people currently.
Professor Winkler, I know this isn't a legal question, it's a political question, but you expressed doubt that the Women's Health Protection Act would make it through the Senate. Would you care to comment more on that? Or is this just obvious to everybody but me?
Does anything ever make it through the Senate?
Well, yes, of course. I mean, our whole discussion would just be academic.
Does anything actually make it through the Senate? I don't know. It's like, a law about X, and I have no idea what X is about. Will it make it through the Senate? No, that's my bet. Well, I mean, no, it's not going to make it through the Senate because you need to overcome a filibuster, right? So the story is with the Senate right now is you have a very tight 50-50 split. The Democrats have control of the Senate because of the tie-breaking vote of Vice President Harris. For Democrats to get a law like this passed, it needs 60 votes. You need to get over the filibuster. This is not one of those financial issues dealing with the budget that can be decided through the reconciliation process that avoids the filibuster. So the filibuster applies here. And there's no way you have 10 Republicans who are going to join up with the Democrats to lift abortion restrictions in state after state. It's just not going to happen, right? There's just there's not a single member of the Republican caucus who has suggested supporting it, much less 10 members of the Republican caucus who would support it. So that's what I mean. It's just not going to get through the Senate as long as there's a filibuster. Frankly, I think if the Democrats got rid of the filibuster, one of the things, I mean, I know a lot of Democrats want to get rid of the filibuster. They think they can get a lot of laws passed if they get through the filibuster. I'm a little bit less sanguine about that opportunity. I think that if they got rid of the filibuster, I think the Democrats would have a hard time even getting the entire Democratic caucus to support a federal bill guaranteeing abortion rights. I think it'd be hard to get the votes of people like Senator Manchin, Senator Sizemore, maybe some others as well, who would be opposed to federal intervention on this issue. And so I just don't see really any prospects for that law being passed right now. One of the interesting things that may happen is if the court overturns Roe versus Wade, and it does lead to a real political mobilization of people on the political left, the way Roe versus Wade itself led to a political backlash and mobilization of people on the right, then it could have a whole bunch of far-ranging issues on a whole bunch of, not just on abortion, but on a whole bunch of issues that are important to Democrats, gun control, other things like that, where if there's a real mobilization that really transforms American politics, then that might change the calculus of these things and their ability to get through the Senate. But certainly under current rules, with the current political dynamics, it doesn't seem possible.
Thanks for that great discussion of that whole process. One quick technical question. Is it possible that the Supreme Court would issue an opinion on Dobbs before next summer? Or is their schedule somehow set in stone?
I don't think that'll be happening. Dobbs is supposed to be argued December 1st, and generally all the opinions are issued in June. And I don't think they're going to decide, it could, but it probably, it really won't. It will be issued sometime in June. So I think we're just going to have to wait on that one.
Okay.
This is the kind of case where every justice is probably likely to write their own opinion in the case and write long and lengthy opinions. This is not a small matter. This is a big matter. And the justices will be writing not just to control the outcome in this case, because their writing happens pretty much after the outcome's been decided, but they're going to want to write for posterity, for the con law textbooks, to shape the political debate that's going to come in the wake of the Dobbs decision. So I think we're likely to have a lot of opinions being circulated among the different justices.
You think all 13 of them?
Yeah. We will certainly have a lot of opinions coming in. And one of the interesting things that might happen is like, you're going to get a divided court. It's very possible you'll have a majority in favor of upholding Mississippi's law, and you'll have 3 or 4 justices that say Roe versus Wade must be overturned, and 2 or 3 justices that'll say, no, Roe, let's keep Roe on the books, but let's allow more leeway, and Mississippi's law is unconstitutional, so we agree with the overturned Roe people to that extent. But you have a divided majority, and then that has to be that's going to be subject to discussion about what is the binding principle that comes out of a split case like that. So I think there's a lot of opinions that are going to be written on this case, a lot of words that are going to be spilled by the justices. And so like Professor Harris, I think unlikely we're going to see anything before June. I guess it's theoretically possible, and certainly possible you might see something in April or May, but it seems hardly likely.
I might point out that Roe came out, in January of 1973. It was my 3rd year of law school. I still remember when it came out. So I don't think Dobbs will come out that quickly. It'll be June, probably the last day of the session.
I'm already canceling my summer trips for next year so that I can be here for that opinion, right? It's going to be probably last week of June. And by the way, we'll also probably be getting, we've only been talking about abortion so far this year. I'll talk a little bit tomorrow about when we do the talk on the Second Amendment. And the story in the Second Amendment is very similar, right? That the court seems to be on the verge of reshaping Second Amendment law and striking down a variety of different kind of gun safety measures, and that's probably going to be coming also in a June decision. There's even an outside chance, I think it's still an outside chance, but there is a case bubbling up through the courts that the Supreme Court justices have expressed interest in hearing, which is a challenge to race-based affirmative action at Harvard University. I think it's just based on the timing. It seems hard that the court's going to get to that this year, but it is possible. And if so, we could end up in June having a case that overturns Roe versus Wade, that sort of supercharges gun rights in America and outlaws race-based affirmative action all in one, maybe on the same day that could happen. So it should be a hot time in the old town in June.
I'm not
Also-
canceling my travel for that. I'm hoping to be on a beach in the Greek Isles as all of that information comes down. Kim?
Yeah, one thing I just want to say is that the Supreme Court, the justices and everyone involved there, they are aware of the political realities of overturning Roe, that there will, if that happens, there will be massive protests. And they don't particularly want to issue that ruling in, say, February and have protesters out there for the next remaining months of their term. So that's another reason why we will not be seeing that decision until probably the last day they are in session. They don't want to put up with the protesters.
I noticed that Professor Reifman pointed out in the chat that Roe was re-argued, which may be a reason it came out in January. I just remember it coming out.
That's right. I think it was re-argued, and there were some empty seats on the Supreme Court the year it was argued the first time. And then the seats were then filled by President Nixon, I think, in the meantime, if I remember correctly. And so it was re-argued and issued then. Don't see anything like that happening in this particular case, but you never know how it goes.
Well, with all those new justices filling the court out to 13, it's going to be wild. I can't decide whether I'm delighted or horrified to see how the sausage is made. I really had very little legal knowledge coming into this. And I've been teaching Latin for over 20 years, and you three taught me a new Latin phrase, stare decisis, if I can pronounce it correctly. I'm terribly confused about the difference between laws and precedents for constitutionality. I mean, when you speak of constitutionality of precedent, it seems to me unusual because precedent is so not flimsy, obviously rock solid in some ways, but not a law. And we're not here to talk about laws, but weird interpretations, I suppose. I don't know that we have any more questions. Do any of the three of you have clarification or questions for each other or any last word?
Just one thing I'd like to ask Professor Winkler, and that is the Commission on the Supreme Court, which based on its membership may very well recommend increasing the size of the court. Again, I'm not sure that would ever get through the Senate, but what do you predict will happen?
Well, it's a great question. Obviously, this has been a big issue among sort of the Democratic base, Democratic activists, maybe less among the grassroots, but certainly among interest groups that are really active in the Democratic Party to get some kind of significant Supreme Court reform. Of course, this was a discussion that was really sparked by the refusal of the Senate to consider Barack Obama's nominee for Justice Scalia's seat. You recall that that senators refused to consider that nomination because it was made during an election year and that the issue should be decided by the voters. But then, of course, the same senators supported the confirmation of Amy Coney Barrett just a couple weeks before the November election of 2020, suggesting that maybe it wasn't principle, but power politics really at play. That's not such a shock where politicians engage in politics. That's not such a shock, but it did spark this desire and a real move and a push to think about Supreme Court reform. Joe Biden, when he was running for president, really downplayed the issue of Supreme Court reform. It didn't seem to be an issue he was really motivated to pursue. And some people have said that the commission that you referenced, Professor Rosen, is really the best indication that he plans to do nothing on it, right? That a commission like this is a blue ribbon commission is where great ideas go to die. And that if Biden really wanted Supreme Court reform or wanted some significant federal court reform in some other way, he'd be working with his advisors to promote a law, to work with Democrats in the House to get it passed and pursue it. But I don't think he really wants it, number one. And number two, again, nothing's getting through the Senate right now, right? No, you're not going to be able to rewrite the rules on the Supreme Court when you can't get anything else done through the Senate. So, and again, even if you got rid of the filibuster, which would be necessary, I think the same senators who refuse to budge on institutional reform of the Senate are likely to be unwilling to budge on institutional reform of the Supreme Court. So I think we're stuck with 9 for a while, and I don't see that changing anytime soon. But I will be interested to see what the commission comes up with and whether that slightly changes the political calculus that some people have in thinking about Supreme Court reform.
Alan also in the chat brought up the idea of Supreme Court term limits, but of course there we're talking about something, a constitutional amendment, something that would be a unicorn.
And we all know how easy those are to get, right?
Oh, yes.
And there's a vision, by the way, there is a federal bill that has been proposed that would limit terms to 15 years. There are a couple mechanisms that you might be able to do it through legislation, not retiring the justices, but moving them into different positions. So there are some, there's been some creative thought about how you can do it through legislation, and there are what seems to be potentially viable mechanisms to do it through legislation. But again, you can't get the legislation through the Senate. So I don't know where it's going.
Well, there's a pessimistic note on which to end our panel discussion. I want to thank all 3 of you for educating me wonderfully. I want to thank everybody who's in the audience for coming up with some questions that made us think. I hope you feel, thank you all, they say. And I just want to reiterate that everybody should turn out tomorrow for Professor Winkler's talk, The Second Amendment at the Crossroads. There's a lot going on with guns in America, as we Texans know, as non-Texans know, and this is going back to the earliest days of the country and figuring out the future. Well, will you predict the future for us about what the Supreme Court is going to do?
Of course. Why not?
Of course. All right.
It's not worth anything. I wouldn't bet on any of it, but.
Well, all right, then I will see you all tomorrow at 4 p.m. Thank you so much.
Thank you all. Thanks, Professor Rosen.